Faculty, staff, alum, thank you so much for joining us in this second of as unyet determined number of panels in the Embedded Racism series here at Vermont Law. Many of you joined us a couple of weeks ago. We were overwhelmed and heartened and awed by the participation. In fact, I think Dean Jefferson said it went on past 8 o'clock, and so I probably won't ask you to do that tonight, but what that told us was that there is, it's more than just interest, it's an imperative, and we hear you, we're so excited about this, and I know Dean Jefferson has received numerous emails with feedback where I ask you to keep those coming because your participation, your feedback, what you want, what you need and demand, we want to give that to you as best we can, and we want to be part of the conversation that you're having. So tonight, we have three speakers. They really don't need an introduction, and in the interest of time, I'm not going to give them one, but they are Pat Parenteau, Joan Vogel, and Anna Saxman, all professors and faculty here. And they're going to speak in turn for about 10 minutes apiece. We're going to have plenty of time for questions and answers. First, I'll say I don't hear any problems right now, but if your microphone is on, please mute it. And when you do have an opportunity to talk, don't forget to unmute yourself for that. Second, if you are, because there's so many of us and we only can see 9 people at a time, if you want to view one person, you can pin them to your desktop. I believe it happens by right clicking on their name, and then you can pin them to your desktop. We will, at the end of each presentation, we're going to give a quick make sure that there's nobody out there that has a quick clarification question. Did you say this? I missed this part. Something that needs to be addressed right away, and we'll give you an opportunity for that. But we ask that all other questions you keep for the end after all three of our speakers have finished, and then we can open it up to the whole forum. When it comes time for asking a question, whether it's for clarification right after the speakers has presented or at the end, there are a few different options. If you are calling in, you're not online here, but you're on the phone, please email. Which one of our ambassadors should they email?
They can email me, Sarah.
Okay. Please email Sarah. I'll give you an email address for that. It's saragaylon@vermontlaw.edu.
Yes.
Okay, great. And then, but if you're not on the phone, you have a couple different options. If you have the version of Teams that allows you to raise your hand, that is, there's a on the menu bar, there's an actual hand like this. If you can click on that, we'll put you in line to ask a question. If you do not have that functionality, please open up the meeting chat function and just type in your message, I have a question. And one of our ambassadors will catch you and we'll get you on the list. And that's pretty much it. With that, I'm really pleased, very excited to introduce Professor Pat Parenteau. Take it away, sir.
Thank you very much, Pam, and hello, everyone. I trust everyone is doing well physically and mentally in these challenged times. I wanted to start by emphasizing the message that Dean Jefferson sent around just today, marking tomorrow, Juneteenth, which of course is the formal announcement of the end of slavery that reached the furthest corners of the Deep South on that date. But as we know, formal slavery may have ended at that time, but we're still living with the vestiges of it today. And it's a particular problem for this series, and I'm going to be discussing just one aspect of that, and that has to do with the environmental threats that are facing communities of color and what we can all do about it. So I'm going to throw out about 5 points quickly, and then we'll move on to the next panelists, and we'll talk about questions after we're all done. I don't think it's a surprise to anyone to know that frontline communities, communities of color, have faced disproportionate environmental impacts for a very long time. Air, water, hazardous waste, the most dangerous kinds of industrial facilities seem to find their way to minority communities in the United States, despite all of the environmental laws that we have on the books and the careful permitting and licensing and environmental assessments that are supposed to be done. And I think the COVID crisis has really brought home just how deeply embedded this environmental disproportionate impact is. The recent studies by Yale and Harvard have indicated that Black Americans are 3.5 times more likely to die of the coronavirus and the COVID-19 disease than white Americans. And for Latinx people, it's almost twice as likely. And that's because their immune systems have been compromised. They're exposed to so many air and water pollutants that they contract asthma and other respiratory ailments, which of course makes them much more vulnerable to disease outbreaks like COVID. And I hate to say it, but listening to Dr. Fauci and others, I think this disease is going to be with us for a very long time, even when we hopefully discover a vaccine. So addressing these underlying health conditions that people of color are facing is a central, I think, requirement of environmental law. Climate disruption, which is the more appropriate term for climate change, threatens even greater impacts. And we see that primarily in heat waves. I mean, we've seen it with storms and floods like Harvey and Katrina and Sandy. But the heat wave problem is one that I want to draw particular attention to, because the models are predicting extreme hot weather throughout the United States in the middle part of this century. Over the last 6 decades, the number of annual heat waves has tripled. CDC is predicting heat stroke will claim tens of thousands of people per year before the end of the century. And those most at risk will be people, of course, laborers that work outside, construction, farm laborers, and so forth, but also people trapped in these inner city, high-rise, heavily concretized environments where the heat island effect is going to be particularly pronounced, and the availability of shade and air conditioning is going to be extremely limited. So just that one problem alone that we know for sure is coming from the increasing temperatures is going to be a major, major problem for these communities. I think systemic racism is built into our very environmental laws. We do not take account when we're setting standards of air and water, drinking water, lead contamination, and many, many other problems. We don't really look at sensitive populations, populations that are exposed to multiple contaminants coming from multiple sources. We've never really been able to look at these problems in what we call a holistic way. There's lots of gaps built right into the very structure of the laws. And then when you turn to the institutions charged with implementing and enforcing these laws, we see what happens with changes in administration. And I don't need to tell you what's going on today with 100 environmental laws and policies being reversed by this administration. That's how fragile our environmental institutions and systems are, that a single person can take charge of the federal government and do so much damage in such a short period of time. The courts are also very difficult to go to for remedies for violations that combine civil rights and environmental requirements. The Supreme Court has really closed the courthouse door to our arguments about the disproportionate and disparate impact of all these sources of pollution and degradation. The two leading cases, Sandoval and Gonzaga, have greatly, greatly limited the remedies that are available through federal judicial intervention. And then you're left with administrative agencies like the Environmental Protection Agency that's supposed to vigorously enforce Title VII of the Civil Rights Act. They have a tiny office, a tiny staff. They're overwhelmed. They're way behind. They have a track record of not responding, not intervening. Their tools are limited. Their political commitment is limited. You can't even rely on the EPA to pick up the slack at least for now.
Professor Parenteau, you were muted. Sorry, I think there was an effort to mute any open mics, and you got unintentionally muted. So you need to unmute yourself, please.
I don't know where that happened, but
thank you. So if you could go back about 15 seconds, that would be great. And I apologize.
Okay, so it comes down to what do we do now? And of course, the first thing is to go and vote on November 3rd. But beyond just individual voting, I think it's a get out the vote campaign. Drive people to the polls, drag people to the polls, encourage your family and friends to go to the polls. Let's hope they pull the right lever, but do everything you can. But beyond that, I think it's incumbent, and I'm going to say this to the white audience. I think this is a white problem. I think for too long, a lot of us, me included, have left addressing these issues to the Black and Latinx communities to bear the brunt and to go to the streets. And I'm heartened to see this time around seeing so many white faces out there on the street and so many young people invested in righting these wrongs, these historic wrongs. We're talking 400 years of wrongs. But for lawyers in particular, it's our particular obligation and our particular skill set that's most desperately needed right now to advocate on behalf of everyone for environmental justice, justice across the board. There's so much that can and must be done to use the tools of law, better laws, improving our environmental laws, getting better people in positions of authority to implement those laws, people that really are in touch with what's happening, people that respect the science, people that are listening to the experts about what we need to do, and then are taking the actions that are needed, whether they're politically popular or not. I'll close with Mahatma Gandhi's famous expression, be the change you wish to see in the world. Let's all commit to doing that. Thanks.
Thank you so much, Professor Parenteau, and I know there are going to be lots of questions for you later. Is there anything specifically that Professor said that you need him to repeat, or something that you missed, or are we okay to move on? Professor Saxman, did you have a question? You're muted. There you go. Oh, you're muted again. Okay, I think we're having some audio problems with Professor Saxman right this second, but we'll, oh, you're back.
You're back. It's muted again.
Okay, so I think what might be happening is that you're pressing it twice, but we'll come back when you've got it worked out, if that's okay, or you can write your question in the chat.
Write it in chat, Anna.
So I don't see anything else right at the very moment. Professor Vogel is going to be speaking about employment discrimination, Title VII of the Civil Rights Act, and I will go ahead and hand you the mic. Professor
Okay,
Vogel.
can everybody hear me? Yeah, okay. Now I won't go through the doctrinal details because that'll bore you to tears. Let me just talk about why this matters. Yesterday I was watching television and watching Vanita Gupta with an interchange with Senator Cronin, and she was talking about systemic racism, and it was quite clear from that interchange that Senator Cronin had no idea what she was talking about. He kept saying, "Are you saying we're all racist?" And she was saying, we all live in a society that has systemic racism, and it's part of our structure. And therefore, it's very difficult for any of us to say we're not influenced by this. This is implicit bias. He had no idea what she was talking about. And this is, in a sense, that exchange was really an indication of what the problem is in employment, in fact, in all kinds of discrimination. the difference between those who see discrimination as a systemic problem and those who see it as a problem of what we would call bad apples. Does that sound familiar? You hear this in the discussion of the police issues. Oh, we just, get rid of a few people and the problem will just go away. Well, it's not a problem of just a few bigoted people. The problem is this is built into our system. I think we've talked about this. You've heard it discussed on television. This is a problem in the whole way you approach issues of discrimination in our country. If you see this as just a problem of a few bigoted people, then your solution will be get rid of them, fire them, move them out of the way, or just have a solution in the law that just simply says somebody has to reinstate an employee who has been dismissed or discharged. They have to hire somebody and the employer pays damages and the problem just goes away. That's been the problem with Title VII. Now, for those of you not familiar with the history of Title VII or the Civil Rights Act, it was passed by, it was the big accomplishment, it was a huge accomplishment of Martin Luther King and the Civil Rights Movement. I'm going to be talking about Title VII, but of course it has a number of titles in it. And when that was passed, the understanding was here, this was the beginning, not the end, what was needed to be done. And the Civil Rights Movement understood that this was going to take a long slog to get the kind of employment opportunities for minorities. And by the way, women and other people are included in the Civil Rights Act. There's a long story about how women were included by a Southern congressman who thought, good, we'll put this in and it won't pass. Thank you so much. You can imagine how long it would have taken us to get that. Thank you so much, you rotten congressman. You put it in for us. You imagine how long it would have taken us to get that. But in any case, this was all put in and it passed. But it's important to understand that that was the product of struggle and protest. And we should never think that anything was given. That was fought for. And we have to continue to fight for it. And what happened after that was that the lawyers struggled and used creative theories to get the court to make that work. And there were two general theories that the courts used, and I won't go into the details, but one of them really incorporated the civil rights movement of systemic racism, that is disparate impact, and the other one included this sort of rotten apples approach, which required the showing of intent, and that is disparate treatment. And the courts have made disparate treatment sometimes difficult to show, but over the years, but they really hated disparate impact. And they've cut that back over the years. Congress even had to intervene to keep them from eliminating it altogether in the Civil Rights Act of 1991. And they wouldn't allow the courts to grant damages for that. The Civil Rights Act of 1965 did not grant damages. It allowed for equitable damages, equitable relief, because they didn't trust Southern juries. And Shirley can tell you the reason why you wouldn't trust a Southern jury with a race discrimination case. They didn't. But in 1991, that ceased to be a problem, but they would not give damages for disparate impact cases. And so they aren't as important as they could have been. They hated these for the same reason Cronin could not understand systemic racism. They thought it was punishing people who weren't overtly bigoted. And if you were not overtly bigoted, why are we dealing? Why does the court have to deal with these cases? That's the problem we now face. The inability for people to understand this is a systemic problem and it requires systemic work. What I think we now, but it was an important statute on itself. We have to realize what we just realized this week. If you have no statute that forbids discrimination, people can be fired for no reason or any reason at all, including race. This week, we had a wonderful decision from the Supreme Court that said people could not be fired because they were gay or because they were trans. And people could be fired except in states that had, and there were about 20 states that prohibit that. But as the plaintiffs in those cases basically indicated, they could be fired just for that reason alone. Before 1965, you could be fired simply because you were Black or you were Latinx, whatever. That could no longer happen after 1965. But of course, you had to sue. And some of these cases, for many years, were successful. Some of them weren't. And now we face another problem starting in the 1990s, which I think some of you may be familiar with, which is that many employers, to make sure these cases are not public, are putting in arbitration provisions. I don't know how many of you are familiar with these, but these basically tell employees that they have to take these cases to private arbitration panels, and they cannot go to the courts. This is a very serious problem for all employment cases, not just employment discrimination cases, which means that, and these are pro-employer, many of the arbitrators who impanel these, you have to pick the employee gets to pick the arbitrator, but so does the employer. And chances are that that arbitrator is not going to be somebody who is friendly toward the employee. So that has become a really serious problem now. So now you may not even have access to the courts at all. So I just want to say that what we learned from the demonstrations this week and what we learned from the civil rights movement, we have to learn all over again. Never forget, you always have to protest, you always have to be political, and you always have to vote. So this, I'm going to remind people that if you have conservative people dominating your courts, dominating the legislature, you don't have any way to deal with systemic racism. And I will stop talking now and let Anna speak next.
Thank you, Professor Vogel. Again, for those of you who didn't hear this at the very beginning, we're going to hold most questions for the very end after all three of our speakers have finished. And so unless there's something specific that you need clarification on or that you missed it, we'll move ahead. With that, Professor Saxman is going to speak on racial bias in the criminal justice system from probable cause to sentencing, and she's going to do it in 10 minutes.
Actually, I'm going to start a little before that. I want to discuss the embedded racism and the cycle that it's created. So years of racial discrimination embedded in our culture has created an environment that has an enormous negative impact on the arrest, prosecution, conviction, and sentencing of people of color. So it's a double whammy. Racism exists in many areas outside of the criminal justice system, but that discrimination is used against people of color in the criminal justice system. For example, housing discrimination, of course, makes it difficult for many people to live in so-called safer neighborhoods due to redlining. Employment discrimination obviously makes it harder for many African Americans to find the good jobs that they need. Education discrimination, media discrimination, we'll talk about those. But let's see how criminal procedure is affected by this. As you may know, to lawfully stop an individual, an officer must have a reasonable, articulable suspicion that a crime is being committed or about to be committed. But the reasonable suspicion factors are often proxies for race. So, presence in a high crime area. Do you see how that connects with the housing discrimination? Not everybody can live where they want to live. So if they're just going about their business and they happen to live in a high crime area, it is one factor that the courts say the officer can consider. But currently, as we see danger from the police, if an African American youth is justifiably afraid of a police officer and runs when he sees that officer, that will be used against him. It may be considered flight in a high crime area. There you go, a double whammy. And that can be considered reasonable suspicion to stop a person under a United States Supreme Court case, I'm sure you all know, Wardlow. But it's a factor, and young people are likely to flee, and it's a place where race and adolescence often converge. As we know, juveniles are more impulsive, they have immature capacity to see consequences, and their frontal lobe hasn't completely developed. And then with young people of color, they've got obviously fear of the police, distrust between police and the African American communities. They're not going to call the police for help when they're injured, and they're going to refuse to help the police in investigations. So if the youth flees and the officer chases, the officer may, in fact, tackle the fleeing person, and then you can kind of see the cascade of charges that may result: resisting arrest, assault on a police officer, etc. Many criminal defendants and their attorneys are trying to fight this sort of embedded racism, particularly in regard with flight in a high crime area. And there are some good cases, but people really should be pushing for this and should have pushed for this for a long time. The reasonable suspicion, cannot include situations far beyond your control. So are there other areas of racism in the application of the Fourth Amendment? Yes. Another factor that can be considered is nervousness. A police officer said that this particular man was so nervous, I knew it was suspicious. Well, I think, and Chief Justice Rehnquist of the Vermont Supreme Court recently in a concurring opinion said, I question whether nervous behavior exhibited by a person of color should ever be used as a factor in determining whether police have reasonable suspicion or probable cause. Yay, Justice Ryder. Furtive gestures. Now, this is where we get into a lot of studies. White people, generally, are more likely to interpret ambiguous behavior by blacks as a way more aggressive and consistent with a violent intention. So furtive gestures may easily become, he was reaching for a gun. And when the same people who were tested here interpreted the very same behavior by whites as less aggressive. This racism is embedded. Other unsupported assumptions that officers may use as reasonable suspicion. Currently, the Fourth Amendment allows pretext stops. The United States Supreme Court said we're not going to look at whether it's a pretext stop or not if the officer had some other legitimate reason, which sounds a little bit like some of the tests in employment discrimination. Oh gosh, I think I saw the brake light out. Maybe it was flickering. That could be enough. The suspect was holding what looked like a gun. Other studies have found, and I think current events and old events will bear this out, white people are more likely to perceive a toy as a weapon if they associate it with a black child. Multiple assumptions. Among the general public, participants perceive African American youth as being more than 4.5 times older, 4.5 years older, than they actually were, and law enforcement about the same. So there we have expectations for African American children that in fact they're 12, but the police see them at 16. Or so interpreting a 12-year-old's behavior in light of what they think is a 16 or 17-year-old. In another one of these studies, participants were shown images of misdemeanor and felony crime scenarios and asked who looked more guilty. Well, among the general public and law enforcement, participants saw white youth as less culpable when suspected of a felony, and of course, black as more. Much of the embedded racism is emphasized by media coverage, as you probably know, and it has been for many, many years portraying black suspects as dangerous criminals, while often whites, even including, the people who do mass shootings, as mentally ill or, disturbs people, which factors into citizens' tips. Police officers can rely on a citizen tip. And as we've seen recently, completely innocuous, innocent behaviors by African Americans have been reported by white people, and the police have to respond. Sometimes a tip turns into a be on the lookout. What happens when the description of the suspect describes the majority of the population in that area? Well, could be anybody, right? A young black man. Conversely, and this is more common in places like Vermont, if the description mentions an African American male, even with some specific description like 6 feet tall, had a hat, the first African American male the officer sees is going to be stopped. So there are many, I think I've used up all my time, there are many, many other subjective factors that have evolved through embedded racism that officers and courts may rely on, but which are really proxies for race. And that's what we really, as prosecutors, defense attorneys, judges, we really need to be on the lookout for that. And happily, there are some courts that are. So I think I'll stop here.
Great. Thank you so much, Pat, Joan, Anna. We have a couple of people who are queued up to ask questions. I'm just going to ask also, just as an overview of the question and answer period, if we might want to have some focus on things that we can do in the near term as well as in the longer term, whether we are law students or are practicing once we graduated and passed the bar, as opposed to just knowing about, which of course you can't recognize injustice until you know what it is and where it comes from, but focusing on some action items. And so with that, I want to start with Christopher, who asked a question earlier on about voter suppression. Christopher, do you want to ask your question? If you're there.
I'll just say asked and answered. Professor Parenteau answered in the comments.
Okay, well, I saw that and I think that's great. I'm really curious about if we might want to be able to go a little bit more into being a poll watcher. What does that take? How can you do that? Can you do that if you are a citizen of, say, Vermont? Is it possible to become a poll watcher in another state? Anybody want to address how that works?
Yeah, that is, I've done it myself, Pam. But you do have to follow the rules not only of the state in which you want to appear, but you have to be very careful to know the election laws of the state and also the customs and practices and procedures of the particular voting precinct that you're in. You have to go there early. You have to introduce yourself. You have to be the soul of politeness and respect and all of that. And you have to sit quietly and not interfere. There's training for how to be a poll watcher, and I recommend that. But it's absolutely doable.
And
There are, of
some
course,
of us,
many other voter suppression issues to think about. The COVID crisis, the mail-in ballots problem, the gerrymandering, the requirements for registration, and whether people will find when they get to the polling place that their registration isn't in the system. There's hundreds of things that can go wrong, unfortunately. And we know the states where this kind of problem is going to occur. They're the almost same swing states as they were in 2016. We know those margins are still going to be problematic. So people that want more training and focus on the upcoming election, let me know and I'll put you in touch with others.
yeah,
Great.
we've had some people do this in New Hampshire where there was some problems with students, college students, and all who wanted to vote, and sometimes people were giving them a hard time. We don't, know whether that will continue to be a problem, but there are ways in which you can do that, even if you're here and you want to do it next door.
Great, thank you so much. And Pat, when you have some resources, we'll make sure they are distributed in a central location for our guests today, as well as in the last panel and future panels. So,
Okay.
Jeff, you had a question to, go ahead, take the floor.
Thanks. Thank you, Pam. I had a question related to sort of what we're talking about in terms of a practical effort that people could make. We had a moment, a lightning rod sort of moment in town here where something very unfortunate but also fortunate happened. A community organizer whose name was it doesn't matter what his name was. He was a friend of mine and a community organizer. He ended up leading a Black Lives Matter march, and he was able to get the town to permit it and to give their police support for it. And this was all positive. It almost rained on us, and it did rain on us. And the fact that we still came out actually, I think, was even more positive. But there is this issue of sort of, he turns to me a little bit as his friend who's a lawyer to sort of figure out at what point is what the community is doing, because he recognizes some very, very deep discrimination here as a person of color who grew up in this community. I am not a person of color, so I didn't experience this discrimination and in the times that I've been here. His issue was what could he do practically? He was circulating a petition at the Black Lives Matter protest that we had in this town and the next town. And what he was trying to do was he was trying to basically institute a set aside. Now, I know that they've done this in the context of hiring state contractors by doing minority set-asides. There's some good constitutional law cases on that. He wanted to do a set-aside where basically the organization that he had created and the march and the things that would come in the weeks and months to follow would basically ask the mayor and council, all white people, all males. We haven't had a female council person even in the 150-year history of the town. So there's a lot going on there. But he would have asked that there would have been a traditionally disenfranchised persons or minority persons set aside. And he was looking for ways to refine that. And I said, well, you can't. I know. I promise there's a question coming. I said you can't make the mayor and council have those people, right? Because they have to be elected. You can't force the mayor and council to have a minority set aside. That's a democratic process. But everybody they appoint and everybody that they hire, which is all of the municipal workers, you could probably do it there, and they could probably do it by local law. And I guess my question is maybe if that's a practical possible answer, does anyone in the speakers or the group see that as something that maybe he could move forward with? Could he have a petition to do an enforced set aside? Because the next thing that happens is when you get your first person of color on the police department, you not only improve community policing, but you also open yourselves up for the next time that somebody who's a blockhead says something ignorant, there'll be a lawsuit. And that's going to cost the taxpayers money, and that's going to get those mayors and councils voted out. So can he do that? Can he encourage them to do that? And would that pass legal muster, do you think, as a practical solution?
Okay, this is sort of in my turf now. You're talking about a certain kind of affirmative action. And
Yes.
Needless to say, the court has been, how shall I put this, less than particularly conservatives on the court, less than helpful on this matter, although the record of your town might be helpful in trying to argue for why this is needed. You can have goals. What you can't have is quotas. we can get into the discussion of why this language can make a difference, of trying to hire people, which encourages diversity. You have to phrase things in very specific ways here of why you want to encourage more people, and have, part of it is the search process that you use, where you've been searching. If they only look at certain people in a very, shall we say, narrow geographic area, then they always hire the people that they know that look just like them. And if you can create parameters for where they're doing their searching, they're much more likely to get a more diverse workforce. And so what you can say is they ought to have goals of having a more diverse workforce. That will get them in far less trouble than if you say we want quotas and you must have, women and minorities in your firm. That'll get them into legal hot water. But if you want to say we have diversity, which we don't have any, and I think from what you say, the composition of the workforce will make that argument for you. I think they will work it, that you will have far less. And you have, there'll be statements, we are diversity hires, we want to encourage people and so on, who are diverse to apply, we take seriously, and so on. And so you've seen these. So there are ways to do this to show that you really care. And they can also hire people who can bring in, who do good searches for them. They can bring in more diverse candidates. That's how you can do this without running into real problems legally. To show they're very serious about this.
Thank you, Professor.
Welcome.
I'll pass it along.
Pam, you're muted.
Okay, I did the same thing then. Thank you for that. Jeff, I just want to let you know that Fiona in the chat also had a suggestion for you. You might want to take a look at that and talk with her.
Okay, thank you.
If you have, yeah, absolutely. If anybody else has a question, either use the raised hand function in Teams or type in the chat, I have a question. While we're waiting for that, Anna, I have a question about the issue of nervousness and the opinion, the Vermont Supreme Court opinion that you referred to, in which Chief Justice Reiber said that, or dismissed that as an element for reasonable suspicion. And what I'm wondering is how that opinion might apply to the question of qualified immunity. Is that now considered firmly established law in Vermont, where if the officer did use nervous behavior as a reason for seizure or arrest, that would not survive a qualified immunity defense?
At this point, generally speaking, nervousness is a factor. By itself alone, I would say at this point, it's not going to be sufficient for reasonable suspicion or probable cause. So.
What is the opinion, just for our reference, if you have?
I just forgot the name of it. It just came down recently. It's one of the public defenders, and it was a stop case.
I believe that was Kansas v. Glover.
No. It's not a U.S. Supreme Court case. It's a Vermont Supreme Court case. But yeah, I don't know why I just forgot about it. We were just training on it 2 days ago. But I will get it to you. Oh, it's Vermont. I got it. It's State versus Clinton Amiable. Clinton-Amiable. 2020 Vermont 30.
Great. Anybody else have a question here?
I didn't get through to through to sentencing.
Oh, well, if it's okay with the other speakers,
Please, go ahead, Anna.
Only if people want to hear about it.
Absolutely.
Well, you know, at any point in the criminal justice system where there is area for discretionary decision making, what charge to bring, how many charges, etc., the possibility of implicit bias can sneak in. And so that kind of follows all the way along. So first, the prosecutor, or in some situations, a grand jury, decide what charges. Then, as whether or not the person will be held without bail. Once again, stats aren't very good, generally speaking. Blacks are often held without bail or with high bail. And then, even if you get all the way to plea bargaining, once again, the plea bargains that are offered, the Black defendants are often longer and worse than they offer to whites. So let's say you find out you want to go to trial in a really white state like Vermont. Black defendants are nervous about going to trial because everybody in the courtroom is white and all the jurors just about are white. So it requires talent and training on the part of the criminal defense attorney to talk to jurors about implicit bias in a way that will discover the true, hardcore racists in the bunch so that they can get them off, but also so that people might have some ideas about it going through the trial. If the person goes to the trial and gets convicted, then at sentencing, I have to say, at sentencing, we have not shown very well in Vermont. And a few years back, I had a great case which I won on appeal, but it was a bad police stop of a Black man, and he was convicted of possession with intent to sell. And at sentencing, now this is a young man, no real priors, and the judge said to him, I see no possibility of rehabilitation for you. What am I going to tell you? Don't do drugs, don't bring drugs. And she gave him the maximum. And luckily, I won the case. Everything was thrown out, and he was a free man. But I would say that there are too many. Vermont has a bad rate of Black men, generally, but not exclusively, in jail, higher rate. And some of it has to do with sentencing. Some studies came out a while ago, and there's a really good law review about this, which indicated that judges were influenced by the Afrocentric appearance of the defendant. The darker, the more, I don't know what Afrocentric means, but you probably do. And the worse the sentence was. That's just unacceptable. It's just horrible. So what you can do, you people who aren't going to be criminal defense attorneys or prosecutors, where you're living, find out what if generally speaking, prosecutors are elected and they have to run for office, find out what's their position, what are they doing, have they made inroads into trying to equalize their charging and their plea bargains, etc.
Professor Baskin, there's a question in the chat for Professor Parenteau.
Yes.
It's Claire. Do you see it?
I do. There's some very interesting chat going on about hiring and the diversity approach to hiring, and so that's something worthwhile taking a look at. And Claire does have a question for you, Pat, about policy or legal innovations or tools that we can use to address heat waves in urban development. And Claire, you're welcome to unmute yourself and speak if you'd like.
You can see my response in the chats, but we could go further.
See, everyone, so some folks are on the telephone. That's the only thing with the chat features, is that people on the telephone, I'm getting some emails from folks who saying they're on the phone. That's why even some of the chats that people are having, if they could talk about them.
Oh, okay.
Yeah, that's the only problem. We got about 5, 6, 7, 8 different folks using different types of devices. We're trying to please them all, but we can't.
Do you want me to say something about what I had written on the chat here?
No, you fine, Professor Vogel. I just think moving forward, even those nice alumni lawyers who have comments, if they could tell us their comments, it doesn't have to be a question. I think because they are so informative and so knowledgeable. So Professor Parenteau, if you could just address Claire's question.
Sure. So Claire was asking, are there things that we can do to address the impacts of heat from climate change, the heat island effect in urban environments? And I cited a few things. There's a lot of focus on this right now in city planning, and Chicago, New York, other major cities are deeply involved in this. And it all has to do with green infrastructure. What you're trying to do is save the trees you have, plant more trees, save the green spaces and gardens you have, create more rooftop gardens, stormwater systems that rely on natural features, even so far as painting some surfaces white to get that albedo effect to reflect the heat. All kinds of ways of softening the urban landscape, absorbing the heat, and instead of concentrating it the way it is now. You can do it through ordinances, states that have what we call little NEPAs, environmental assessment laws. Some of them are much stronger than NEPA. California comes to mind. New York has a strong one, Montana. And those kinds of laws are a lever that you can use on development to make sure that they incorporate these kinds of techniques to soften the impact, not just of heat, which is a big concern, but also stormwater runoff, which is going to be increasingly a concern in parts of the country. So that's where the action is on this issue. It's a local kind of issue with local ordinances, county ordinances, and then whatever laws you have at the state level primarily. You can also look at federal infrastructure development and whether or not it's making these problems worse or not, and that introduces a whole number of federal laws, which we don't have a whole lot of time to go through. But there are plenty of legal handles on these problems when you look.
Great, thank you. Again, if you have a question, we'd really like to hear from you. It sounds like Claire's mic wasn't working, but Bobby Sand has a question for you, Anna. Professor Sand, can you turn on your audio for us, please?
I can read it.
Okay, so he asked Anna, do you think public defenders are subject to implicit bias and be willing to accept or recommend offers for defendants of color that they would not accept or recommend for a white defendant?
I think all of us are subject to implicit bias. It's so hard to say whether or not someone will be willing to recommend. I hope that's not the case, but I think that all of us should be aware. We've been trying to train on this. So there might be situations in which, as you have pointed out, some African American people don't want to go to trial in Vermont because they're terrified, as there's nobody on the jury who is Black, and so sometimes they will accept possibly a lousier deal because of that. And I don't know if prosecutors are taking advantage of that or not. Perhaps you do.
Thank you. Do we have any more questions here?
Yes, Gabrielle has a question. Gabrielle, can you unmute your mic? If not, I'll read your question. Either Professor, do you see it, Professor Vaslin?
I think I'm unmuted now.
Okay.
Thank you. I didn't know I was going to take airtime. I thought I was having just a little side chat, and I'm looking forward
your
to hearing
question
from
is
you,
very
Dean Jay.
important. It's very
But
important.
you know, there's so many things we can all do, but right now it feels to me like I'm going back and forth in a burning house, not knowing which way to go. Because there's such urgency in things that are happening. And I'm wondering, from expert perspectives of people who are activists and out there, what are the most urgent things we can do? There's people dying so quickly, and we have an election coming up, and, it's a moment in history. I think that we need to be very, strategic about. And one of the things for me is that I can't put myself in crowds, so I'm not going to be going and doing the polling booths or driving people to the polls. But there's a lot of people who can be activists maybe from their homes, and I'm wondering what people see as the most urgent actions we can take right now.
Well, speaking out, calling out racism wherever we see it, writing letters to the editor, using social media, querying your elected representatives on their positions, just being very active citizen Democrats in every phase of our life for as much time as we can devote to it. But white voices and white pressure on white politicians is the name of the game right now.
And also, I think if you could donate it's a couple of agencies out here who are raising money to get the protesters out of jail. As you know, a lot of protesters were in jail, and some of their bails were $1,000. And that's what they did back, I want to say, in the olden days, that they set up a fund. They had some lawyers working on getting them out. Then they had some folks who was raising money to help them, because some of those protesters don't have money, being that they are out of jobs based on COVID-19. But you also, Gabrielle, what I always say, it has to be the people. We can't depend on the government, the Supreme Court, anybody. It's us. And we ourselves have to reach down, deep down sometime and say to ourselves, what is something that we can do with our own selves, starting with ourselves. And you got a boy, I know you've been teaching him. It starts with children, teaching them about the color of your skin don't mean any difference, all of those things. But it has to be the people. That's what I think was wrong with Brown v. Board. It was the Supreme Court that said that we should all be integrated. All we wanted was to have a school that didn't leak, teachers that could teach us, and books. We wanted books, all of those things. But they threw us together. And then we weren't ready to be together. We didn't want to integrate. White students didn't want to integrate. All we wanted was equal. And so that's why we're in this predicament today. It has to be us. Are the neighborhoods are still white? The churches are still white. If all of your friends are white, and if all of your friends are black, if you're black and you got all black friends, and white if you got all white friends, then you need to reach out and get some folks that don't look like you. But I believe in the power of people, and I believe in these young people today who are not taking it, and it's going to take all of us. But we can start with ourselves.
There have been some great suggestions in the chat about speaking out against racism when you see it, and that some people aren't even aware or that they are acting on biases that are internalized. Constant self-reassessment and acknowledgement is necessary. Kia had a couple of great suggestions in addition to helping people get out of jail, and Ricardo twice suggesting donating to nonprofits. Kia also suggested donating to the Alumni Office of VLS for students of color. Some of us
wow.
Just studying. So right on. Calling policymakers, volunteering in communities of color. And now Anders Newberry had a question For you, Anna, any thoughts on the possibility of doing some criminal proceedings without the defendant being visible in order to reduce implicit bias on the part of judges, juries, prosecutors, etc.? Perhaps this is more possible now that so many court proceedings are being done remotely. What do you think?
Interesting question. Of course, as I'm sure Anders knows, the defendants have a constitutional right to confront the witnesses against them, to cross-examine. They have a right to be present at voir dire and every other step. So they would have to waive all of those things. And I think the image of a missing defendant, there have been some very highly publicized cases in which the defendant wouldn't, often wouldn't shut up, and they would, gag them and move them, and it didn't go well for them. So I don't know, without being there, having to waive all those constitutional rights and then not being there, I think it sends a bad message to the jury. But if there was a person who wanted to try it, they would have to waive everything. I don't know if the judge would let them, but it's a thought. And as you point out, so much is being done remotely. And of course, in general, we are fighting that because we really don't think that people should be entering pleas by the telephone or having to cross-examine a witness over the phone, not that you can actually see. You don't know what they're reading or doing. So it's currently, it's kind of a big mess, but interesting idea, Anders.
We also have additional recommendations, including educating racist family members, letting them know that you don't stand for it. Join your company or job diversity committee. Draft a letter to ask police, fire, and state officials that a cost associated with the application to waive the fee. Janelle, if your question was answered by Professor Parenteau, she asked a question about the emphasis on white people and our obligation to actually get off our butts and do something. But a lot of white people, Janelle writes, including those in higher positions, don't understand institutional racism or even believe it exists. How do we have those conversations?
One of the problems with the terminology is you don't have to be necessarily a racist to be part of systemic racism. This is a long, long process by which our institutions have become immune to the effects that housing, healthcare, education, environmental protection is having on people of color. We just haven't really paid attention and thought hard about why is it that black people are dying at 3.5 times the rate of white people right now, every day in America as a result of this disease. Those questions are beginning to be asked, but they need to penetrate every single institution that needs to reform. So you don't have to be a racist. This is Cornyn's problem. He thinks in order for me to acknowledge that we have a systemic racism problem, I have to admit that I am a racist. He may in fact be a racist. I don't know. But that's not the question. The question is, do we have a system that systematically disadvantages and punishes and harms our black and brown brothers and sisters? And the answer is yes. And if we haven't gotten it yet, we need to just keep at it until we do.
Well, that was one of the reasons, I can chime in here, one of the reasons I started with that was because if you don't see systems, and I think sometimes there's deliberate blindness on the part of some of our, particularly some of our more conservative members of Congress, because they benefit from these systems and they don't want them to change, Cornyn in particular. And so they object, and then they say, well, you're saying I'm racist. The point is, as you just point out, we benefit by some people, and many of us in here may benefit by those systems. and then we don't want them changed. And so if you deny they exist, well, then of course, if they don't exist, you don't need to change anything. And I think that is part and parcel of the discussion that he was having with Gupta, because he didn't want to talk about something he didn't want to change.
Power never gives up voluntarily.
No,
Yeah,
Pam, yeah, there you go.
There's a question from Matthew for you, Anna, about a recent case. And Matthew, you're welcome to speak yourself. I don't have to read your question.
Oh, yeah, I was just making a comment that I'm practicing in Ohio in conservative areas. I had a case where I had a black client riding passenger with a white driver. I know from previous experience with the drug task force that they look for white females driving black males, and they profiled those cars and pulled them over. My client was pulled over for a license plate light out. They said they were overly nervous. They pulled both of them from the car, calling the drug dog. Of course, the drug dog alerts, and then they search the car, find a gun, no drugs, and their excuse is that drug dogs can smell for 48 hours past when the drugs are in the car. So we have a suppression motion in 2 weeks where I'm arguing that there was no reason to extend the stop and that the dog alerted improperly. And so, I mean, you see this all the time, that they're profiling certain clients of mine to find a reason to stop them when they basically always can if they want to.
I assume that your motion to suppress is under Rodriguez, that they unlawfully prolonged the stop without additional reasonable suspicion, and that in order to order them out, they got to be reasonably sure that the person was armed and dangerous. So two things going wrong, and then, well, the drug dog. But to me, it's a winner if all they have is nervous. And I can, if I had your emails, I could send you a couple of the cases. There's one from Massachusetts. There's one, a new one, well, not that new, from DC on nervousness. Your client is the driver, right?
No, my client was the passenger.
Your client
responsibility for the gun.
Okay.
Yeah.
All right. Well, you should win.
I should, but with some of our judges, that's always a toss-up at the trial level.
You should appeal.
So, any resources that you have that go towards this discussion of nervousness? Professor Saxman will get these posted. There are also some really great suggestions for reading, and again, I'll go through and we'll pick out all the suggestions and post these as well. So for those of you on the phone or not in the chat, you can hear those. We do have a question from David about thoughts about redirecting funds from, quote, policing. Where do those funds go first?
I was just about to type a response, but let me just say it and let others chime in. Camden, New Jersey has a very fine program to look at for this. When a 911 call comes in, there's a screening that goes on as to whether this is a health check, a domestic dispute, a person with mental history, or other issues that police really have no skills and shouldn't be doing. And even police chiefs are saying that over and over again. And that program, apparently, it was news to me, but that's been in place for years, and it's been very effective. And not one of their interventions has ever resulted in any injury, let alone any death. And they handle many, many calls. I don't know how many, but many, many calls that would otherwise go to police, leading to, the kinds of horror shows that we're seeing. So Camden apparently has figured out how to screen these calls and redirect them in a way that avoids some of these problems.
Professor Vaslin, there's a question from CJ. CJ, can you unmute your mic? Or do you want me to read your question for Professor Parenteau?
Hi, DJ.
Okay.
I think Professor Parenteau already answered my question.
But can you say it again? Because like I said, I know some folks on this, their telephones would like to hear the answer, because this is a very important question that I know that the Black communities.
Sure. Yeah. So I was asking Professor Parenteau, or merely commenting that a lot of people in the Black community really don't understand issues concerning green energy and things of that nature. And I think that there needs to be education around that. I think a lot of the topics are foreign to our communities.
Yes.
And if we just think about Black communities, there really needs to be a complete overhaul. We don't want to go in and piecemeal anything. We need to kind of look at it from a holistic standpoint and take notice and aim that there are bigger problems that exist, but we need to kind of come in and really just kind of, look at it from a holistic standpoint. So I think education around that topic specifically.
Absolutely.
And so you agree? Yes, because I know that that's I know my own brothers and sisters down in Selma, Alabama. They don't know anything about the toxic, the dumping that's in our own backyard. They don't know that's toxic. They don't know the terminology, and lead paint is still running rapid. So that's kind of getting to me right now, just what she just asked, because it's really that's part of this whole process also.
Let me just chime in and say the environmental community needs to get its act together as well, not only in terms of the underrepresentation of people of color in terms of the professional positions. It's improving, but it needs to go a lot further. But also the work that environmental groups often do has spillover and effects and unintended consequences. For example, we have a legacy of coal ash. Coal ash is a toxic substance. It's not regulated as such. It should be, but it is. It's got heavy metals, arsenic, and other things in it, very bad. And all of these former coal plants have piles and piles of this ash all over the South, primarily the Southeast, which is slowly being cleaned up. But where's it going? And that's the question. If you're going to dig it up in Tennessee and take it to Alabama and dump it on the folks in Alabama, that's not a good outcome. And environmental organizations need to understand that and be careful when they ask for something to be done in one place that it doesn't move the problem to another place, which can be a minority community.
Thank you, Professor Parenteau.
We do have a suggestion for newly admitted attorneys and longer practicing attorneys doing more to reach out to each other for help and feedback. Absolutely. And then Casey asked a kind of a meta question. Practically speaking, what does a world without racism look like?
We're still searching for that.
Right.
Yeah.
I'm not sure it exists anywhere in the world.
No, but I agree, and it's definitely something to continue to think about. I apologize if I've missed any other questions. If I have, please speak up here or raise your hand. There was again, a lot of really good conversation going on in the chat that we tried to cover as much as we could, but if there's something that you believe that you would like to have posted or made available to people after this call, please let us know. As always, Dean Jefferson is taking your recommendations and your feedback so that we can continue to improve these. And it looks like Terry Ann Campbell has a question, so please go ahead.
Hi, Professor Breslin. I don't have a question. I have a statement. I want to say something. Like white people, stop asking what you can do. There's so much you can do. Racism, all of this implicit bias is caused by the people that you know, right? Black people are the victims of the racism from your family, your friends, people that you live around, your neighbors, right? Are you speaking up when somebody says something that has an underlying implicit bias or racial tone? Do you stop the person? Do you say something? Do you intervene? Do you speak up for someone when you're in their presence? When you're behind closed doors and things are being said, right? If you have the power to hire a Black person because you know that they're even overqualified for the job, are you stepping in and doing that? Are you doing your job? Are you doing your duty to stop this racism that is being inflicted on us over and over again? Stop, ask what you're doing and do something. If you hear something, if you're in school, speak up. Volunteer. There's a lot to be done. Vote and help us to fight racism and stop this. Stop. A lot of people are here, they cannot get jobs, right? Because even as a law student, we're in this profession. Legal profession is the least diverse profession in the U.S. Why is that? It's not because Black people do not want to go to law school. It's because of the whole entire systematic racism that we're talking about. So before you ask what can you do, ask yourself, what have I not done?
We hear you.
Yeah, that's why I said, Terry, and you just start with yourself, but you really you went farther to say, not just start with yourself, just start looking at the things that you're doing and looking around you. That's right, it's the people. That's why I always
look around us. Look around yourselves, ourselves. Let us all take that inner, look at self. Is there something that I could have done? Okay, I've learned from this experience. Can I do something next time that I'm faced with this similar situation to make something better of it?
Absolutely. It's easy to just have regrets later, and I think we all agree with you. And I really like the way you put it. Ask, what have you not done, or what have I not done, or so. Thank you, Terry, and I appreciate it.
Right, and it's not too late. It's not too late.
Better
if
not
you want to start right now. Start today. Okay, thank you guys. Love you. Bye.
Thank you. Bye, Terry. It's almost like John F. Kennedy. That's not what your country can do for you, but what you can do for your country.
There you go.
Right back to the basic.
Yep.
Okay. I don't know, Professor Vassar. It looked like this has been good.
I think we're winding down here.
Yeah.
But as always, I love the difficult conversation, or as my sister, who's a school teacher, calls it, the courageous conversation.
Yeah.
We can all be more courageous. And I want to thank you, our speakers, Pat Parenteau, Joan Vogel, and Anna Saxon. I know that you are all going to be available to and interested in any personal feedback or additional questions. So I'm not even going to ask you if you will be. As well, for you, Dean Jefferson, thank you so much for
thank you
being a part of it.
We'll be having more. Our next panel is going to be Professor Hilary Hoffman and her co-author on the book that they're writing. They're going to talk about racism, embedded racism in Indigenous Americans' laws, talk about mascot and all of that. So that's going to be after the 4th of July, and that's when their book is coming out. So we're going to talk about Indigenous Americans. That's what she said we were being called, not Native Americans, but Indigenous Americans. And so we're trying to put this on.
That's 3 weeks from tonight, right? Not 2 weeks.
Yep. And just for the rest of the people on there, I am going to get some law enforcement up in here too. We all can hear their side. So I'm going to need you, Professor Saxman, to help me with that, and maybe Professor Parenteau, because I received emails from alumni who have said that they would like to hear the other side, have a panel with both. And I think that's only fair, because it's going to take all of us to get us to where we need to be. Okay. So thank all of you all. I really appreciate it, and keep the fight.